Afternoon. Our last case is in Ray A.H. Again, we thank counsel for your flexibility, and I'll note that Justice Riggs is recused in this case. We'll hear from the appellant.
Thank you, Your Honor. May it please the court, my name is Annie Wright. I'm from the Watauga County Bar. I'm here on behalf of Stokes County Department of Social Services, which I might refer to as DSS, or the department. The department is the appellant. Also, here as an appellant is the guardian ad litem, represented by Mr. James Freeman, and we will be splitting our time. So we will also be reserving 4 minutes for rebuttal. This is a case about whether a 9-year-old child who was running towards a busy street was properly adjudicated, neglected, and dependent when her father, who was with her as she was running towards that busy street, got in his car and left town, leaving her unsupervised for an indefinite period of time by the side of that busy road. The child in question was 9 years old. This was a 2-lane road with a 45-mile-per-hour speed limit that was heavily traveled at that time of day. It was around 3:30 after school. She was crying. She was upset. She had shown that she could not properly navigate the road. As she ran into it, she ran in front of a dump truck and narrowly avoided being hit by the dump truck. And when the case came before the trial court, she was adjudicated to be a neglected and dependent juvenile. She was not neglected to be an abused juvenile, but the Court of Appeals reversed that. The Court of Appeals looked at the narrow events of her running into the street and whether or not that could have been avoided, and whether or not there was any neglectful act of the father in her running into the street, and did not look at the substantial harm that could have come to her in being left unsupervised for an indefinite period of time. The trial court made the finding of fact that she was at a substantial risk of harm by being left unsupervised, and when the Court of Appeals went back and looked at it, they minimized that risk, saying that the father's actions were not neglectful enough to support an adjudication of neglect or dependency, because he had 2 other children that were in his vehicle that he went back to attend to. The department's position would be that what is determinative of neglect or dependency is whether or not the 9-year-old who was adjudicated, whether or not she was at a substantial risk of harm, not necessarily whether or not the father appreciated the harm, or whether or not he could have done anything to prevent her from running into the road. There is a case cited in the principal brief for the department. It's Henry K.J.M. It's a case from last year. It's a Court of Appeals case, so it's not binding on this court, but I do think it is helpful to look at it. In that case, there was a child, a 6-year-old child, who had been left in the care of a family friend when the mother was incarcerated, and that family friend was then arrested. And in looking at that case, what the Court of Appeals said is that it's not whether or not there was harm to the child under the care of the family friend. It's that the child was left without a caregiver for an indefinite period of time after the family friend was arrested. And that is the same case here.
Well, in this case, how can we not take into account the fact that there were 2 younger children in the pickup truck? I mean, isn't this parent in the impossible situation of, either he's going to be neglecting the 2 younger children, or in your version, as you've told us, he's neglecting the older child? He can't be in 2 places at one time.
The father can't be in 2 places at one time, but when the 9-year-old ran across the street, she could see her father getting into his vehicle. And I think from that you can surmise that the father could have seen the vehicle from the opposite side of the street as well, if he had tried to follow her and prevent her from getting into further harm by being upset on the side of the busy street. But I'd say that regardless of the reason that the father left, the end result was that she was there without any supervision. And with the department, after their arrival, not knowing how long she would be without supervision. The petition was filed roughly 23 hours after the department became involved, but the department had no way of knowing how long their intervention would have been needed, because in that 23 hours, they had not heard anything from either parent. The child had not been in her father's custody for very long at the time of the department's involvement, and had not lived in the neighborhood for very long at the time of the incident. And the child, the evidence would show that the child, there was a bus stop that was about 30 yards from the family home, and that the child was either driven by an adult to and from that bus stop or escorted by older siblings. And I think that, in connection with the evidence that she ran into a road looking behind her, not looking at the traffic, and narrowly avoided being hit by that dump truck, shows that she didn't have the maturity to be left there. And, you know, if we're going to weigh the father's choices in attending to the two children in the truck and attending to the child on the side of the road, you know, on one side you have an upset child running by the side of the road, and on the other hand you have two children that are inside of a vehicle. You know, if mom runs into the grocery store for a few minutes and gets word that, you know, the two kids that she left in the car, one is still in the car and one's running beside a busy road, mom goes to attend to the one that's running beside the busy road first, not to the one that's still in the car. The trial court appreciated that risk and properly made a finding of fact that she was in a substantial risk of harm, and properly found her to be both neglected and dependent. The Court of Appeals found that several of the findings of fact were not supported, and the department would concede that there were portions of some of the findings of fact that were not supported, but the majority of the findings of fact were supported. Just because a finding of fact is based on testimony evidence does not mean that there necessarily has to be a accordant finding of fact that the testifying witness who gave the evidence for the finding of fact was found to be credible. The fact that the trial court makes a finding of fact based on a witness's testimony is inherent of itself, that there is a finding of credibility. And there is some discussion, I think, in the majority opinion and the dissent about whether or not the father saw that the 9-year-old was going to be hit by this dump truck. You know, at what point did he turn around? You know, how far was she into the road? Was the dump truck visible to the father? You know, and I think that that's kind of a false distinction, in that her running towards a busy road is danger in and of itself, regardless of whether there's a dump truck in the road, a car in the road, a motorcycle, whatever is coming there. A heavily traveled road, 45 miles per hour with no sidewalks, is dangerous for any upset child to be running toward. There was an eyewitness who was driving behind the dump truck who saw the 9-year-old running towards the road, the father running behind the child, the dump truck was hitting the child. Luckily, that eyewitness was able to pull over to the road and had good intentions, and was able to get the child into their car and eventually call law enforcement, but it could have just as easily been someone without good intentions who had stopped, which is an additional danger to leaving a child of this child's maturity on the side of the road. And if there aren't any more questions, then I will let Mr. Friedman address the court further on the issue of dependency.
May it please the court. I'm James, Honorable Chief Justice and Associate Justice. I'm James Freeman of the Surrey County Bar, here today for the appellant guardian ad litem. The competent evidence supported the trial court's findings of fact, which in turn supported its conclusion that Aaron was both a neglected and dependent juvenile under our statutes at the time of the filing of this petition. 7B1019 provides that a dependent juvenile is one who has no parent, guardian, or custodian to care for them, or a juvenile whose parent, guardian, or custodian is unable to provide for the juvenile's care or supervision and lacks an appropriate alternative child care arrangement. Competent evidence in the trial court's findings show that the respondent father had had temporary custody of Aaron for 5 months on October 4, 2021, the date this incident happened. Aaron's mother lived in Winston-Salem. The Court of Appeals majority does not seem to contest at the time of the filing of the petition, respondent father was unable to provide for Aaron's care. As he left her after she ran into the street in front of a dump truck and never returned to the scene of the accident, his home in King, or made any contact with Stokes DSS, whom we found out later he knew had Aaron, and Aaron's mother was unable to be located. The majority does claim that the department failed to present sufficient evidence to support the trial court's finding that the parents lacked an appropriate child care arrangement. The dissent in the Court of Appeals from Judge Flood disagrees and points to findings 59 and 62, both supported by competent evidence that supports the trial court's finding of dependency. As these findings recite, the father left the scene and was unavailable, which is uncontroverted. It also found the stepmother uncooperative, and it states that the juvenile's mother was unable to be located, also uncontroverted. In addition, finding 61 finds that neither the father nor the stepmother was suitable to provide care or supervision for the child. The father, because of his absence and failure to contact DSS or make himself available. The stepmother, because of her actions in calling Aaron a pathological liar and refusing to provide the social worker any information regarding the father, including his name, his whereabouts. She claimed she had not seen him, did not know where he was, and did not know how to get in contact with him. And further, for refusing to turn over or identify any of Aaron's belongings to the social worker or even tell her where her book bag was. The reasoning behind Judge Flood's dissent is sound. At the time of the filing of the petition, both parents were unavailable to DSS and therefore could not and did not provide an appropriate alternative child care arrangement to DSS for Aaron.
So is there no time over which the issue of whether or not a child is dependent should be determined? In other words, as I understand it, this incident happened around 3 o'clock in the afternoon. They went to the house and completed the home visit by 5:30, and the next morning they're in court with the petition. And it just seems to me, if there's a legal conclusion that these facts are sufficient to show dependency, that any time a parent, through miscommunication, crossed wires, unavoidable consequences, leaves their child at daycare after it closes, and the child is sitting out there a couple of hours, not a safe situation, not anything parents want to have happen, but does that mean that child is dependent and the parents cannot no longer provide for them?
Well, Justice Earls, in this situation, and I think you're right, these situations are fact specific, and in the situation you're describing, where if there were daycare workers there hopefully was some communication with the parent, because usually at daycares they do have parents' phone numbers. But in the situation at hand here, the department had no information as to the whereabouts of the father. The stepmother was totally uncooperative, claimed the father was not even there, that it was her brother, in fact, that had chased the child into the street, that she didn't have the father's contact information. And the social worker said, please, if you have contact with him, please give him my number, have him call me. Because the department could not provide legally any care for Aaron without taking 12-hour custody, they did, which doesn't mean they have to file a petition.
Right, and there was nothing about the home environment itself. When they went, and correct me if I'm wrong about the facts, but when they went to the home, there was nothing about the home that, that there was not adequate food or heating, or the house was in such disrepair that it was a threat to the health of the child. And there was nothing about the home that meant that the child couldn't simply be returned there and live there.
But that was, Justice Earls, I would say, but that was not, according to the stepmother, that was not the parent's home. She told the social worker that the father did not live with her, that she did not know where he was. He had custody of Aaron. The stepmother had no custodial rights whatsoever. She was not a parent, she was not a custodian, she was not a guardian of the child. She was totally uncooperative. Her hostility extended to the fact she called Aaron's names. Aaron, whose testimony was found credible by the trial court, had previously told the social worker that she witnessed domestic violence between her father and this woman, that they smoked weed in the house, all sorts of different things, and then couple that with the attitude and secrecy, and then admitted lying. The stepmother at trial admitted that she lied to the social worker on basically everything she told her. I would contend that the trial court was warranted and competent evidence supported that the stepmother, in fact, as set out in finding 62, was not a suitable person to have care and custody of Aaron. Therefore, there was no, I do agree with you, Justice Earls, that because the stepmother presented herself there, that was something that had to be evaluated there, but by the evidence presented and the trial court's finding being fully supported that she was not a suitable person, then no alternative child care arrangement existed on its face. And the holding of the Court of Appeals majority essentially holds that, in fact, the department would have either had to manufacture evidence on what a father or a parent would say when they did not and could not speak to them before the petition was filed, or utilize post-petition evidence, which this court has repeatedly said we don't do. In the recent case from this court from 2022, In Re LNH, which I would contend, Your Honors, is squarely on point on this issue. In that case, the child, which was an infant, had allegedly the mother had burned the child's feet, was in jail under bond. The child was in the hospital getting ready to be released. The department went to interview the mother. The mother told the social worker that who the father was, but she didn't have any contact information for the father. And so the social worker went back, received calls from the mother's relatives that day saying they were willing to assume custody or placement of the child. The next day, the social worker filed a petition alleging neglect and dependency, and the trial court found both. The Court of Appeals had reversed the dependency finding by the trial court, saying that the trial court should have made efforts to locate the father. There was no findings, no evidence as what alternative child care arrangements the father would have, and then of course should have allowed the relatives that presented themselves. This court held that the father's absence and inability to be contacted at the time the petition was filed, meaning satisfied going to him to see if he had any available acceptable alternative child care arrangements. And it also said that because the department had not had an opportunity to do a home study on the relatives, there were no acceptable alternative child care arrangements available and the child was dependent. I would contend that that case is directly on point with this case. At the filing of the petition, the department, which was 24 hours later, still had no contact from this father. They had not had any contact from the mother. They did not have a way to contact either parent. There was no suitable arrangement available. Neither parent was available to provide a proper plan for this child as the trial court found, or to provide the care themselves. So the child was dependent. The cases cited by the majority are in opposite of this case. The KCT case dealt with a private TPR. And in that instance, the mother herself testified at trial. And there was not a finding that she had not proposed or that she lacked an appropriate alternative child care arrangement. And this court noted in its decision in sending that back that the mother was not questioned about potential alternative child care arrangements during her testimony, in addition to there not being a finding. In our case, because we were dealing with an initial adjudication, you're dealing with a different time frame than you are at the TPR stage. In our instance, the seminal moment is the filing of the petition. At the TPR, we were talking about up and through the TPR hearing, not the filing of the petition. So you're dealing with a different standard, a different time frame to look at. And so in that instance, the KCT case is not applicable. Likewise, the PM case, which is a 2005 Court of Appeals case cited by the Court of Appeals majority, simply dealt with a situation where the finding itself, there was no finding whatsoever that indicated the parents did not have an alternative child care arrangement, and the Court of Appeals remanded for further findings on that issue. And lastly, the DRJ case from this court again dealt with a TPR motion and again cited KCT because the parent in that instance was not questioned at the TPR hearing and therefore no evidence to support a finding on alternative child care arrangements. As for the dependency situation in this case, I think what the Court of Appeals majority would be holding is in essence that if you've got an absent parent at the filing of the petition, that essentially, unless the department could manufacture some evidence on what that parent would say with regards to an appropriate alternative child care arrangement, then you could not have a dependency allegation in the petition, which does not seem to make any sense, because the absence of a parent and the inability to care for his or her child or to provide a plan for them seems to be the core essence of dependency. So I thank you for your time. We would contend that the dissent reasoning is sound. The fact that both parents were unavailable to provide proper care and supervision to make an alternative plan for the child is sufficient to support both prongs necessary to support a dependency adjudication. The proper inquiries at the time of the filing of the petition. DSS was not required to prove the stepmother could not make an alternative plan because she was not a parent, custodian, or guardian. Those are the three people under our statute that have to be included. She was not a proper person to provide that alternative placement, and the trial court so found. We would ask the court to reverse the Court of Appeals based on the dissent's reasoning. Thank you very much.
Thank you, counsel. We'll hear from the appellee.
Good afternoon. My name is Mercedes Chutt for the the respondent father, who's the appellee in this case. And I'm just going to refer to him by the name of the father because the child and the father have the same last name. So I want to first go a little bit in the background of the case, which is not in our brief or any of the briefs, about this father. Father gets out of prison in January of 2021 after serving an 8-year sentence. He had only spent the first year of the child's life with her. When he gets out of prison, he immediately begins to try to reestablish a relationship with this child. There is an order in the Record of Appeal from Forsyth County, and then there's a whole Forsyth County file around page, well, it kind of goes reverse chronological order, but it's around page 80. And basically, father, after sharing custody with the mother, determined he and his wife, this is the same stepmother in this case, but I call her stepmother, he and his wife, he filed a pro se custody complaint in Forsyth County, a pro se motion for emergency custody. He got emergency custody in Forsyth County. The matter came on for hearing again. I think this is about May the 27th. He filed, I think, on May the 19th. And that pro se in the Forsyth County judge found that the child had been basically abused at the home of the biological mother, and she had been subjected to discipline such as locking her in the basement. She had been made to sleep in a bed with other children and sometimes an adult male. She had been physically beaten by the mother. I mean, particularly when the mother was using drugs, and then the biological mother was addicted to, I believe it was methamphetamines and marijuana, and actually used those substances in front of the child. And the child actually said that, you know, when mom, you know, got high on these drugs, she would start beating me. And so this was an abused child. And the Forsyth County District Court judge found that my client also found that the child had lacked poor housing and poor hygiene, wasn't bathing, wasn't brushing her teeth, just dirty, clothes weren't appropriate. And there was also a CPS worker there from, I think it was Yadkin County, which I assume is where the child was living. So the CPS worker was subpoenaed by my client. The CPS worker provided evidence that my client's home was a fit and proper home for the child to live. The child had been, you know, from what they could tell, abused by the mother, and that my client, since the child had been put in my client's care, pursuant, I guess, the temporary custody order, the emergency custody order, although I think it was earlier than that from what I'm reading in that file, that the child's, you know, hygiene had improved, she was dressing appropriately, she was being cared for appropriately, she had a proper room, she was in a safe home. The stepmother, the same stepmother here, was, you know, working with her, you know, and the father, she was bringing appropriate medical care. And also found, I think this is very telling in that order, that stepmother had 5 other children. And Aaron, this child, did not know them. And so in order to try to acclimate Aaron, both, I guess, to him and to that family, my client rented an apartment across from where stepmother and the children were living and stayed there with his child so that his child would feel comfortable. Now, when you get to what happened on October the 4th, there's nothing between that Forsyth County District Court order finding that my client is a fit and proper person for care and providing good care, and the events that occurred here.
Well, they had moved.
I'm sorry?
They had moved.
They had moved. That is right. They were in the...
Everybody had moved in together.
Yes, they had moved, and they had moved in together. And so what the evidence shows doesn't show that Dad wasn't living there. What the evidence shows is that they were in the process of moving. The stepmother had just bought the home, basically. The stepmother's a licensed professional nurse. Stepmother had just bought the home, and they were in the process of moving when all this happened. They had already enrolled the children in King Public Schools. So the child started to go to school at King Public Schools. And, you know, as I think, you know, Ms. Wright pointed out, I mean, the child was escorted to the bus stop. She was picked up from the bus stop. She wasn't allowed to go to the bus stop by herself. Simply no evidence of a neglectful situation prior to October the 4th. Now, what you have on October the 4th is that, this child who, had been abused by the mother, became very upset that Dad was going to punish her. Now, she claims that he was going to punish her because she told their family business, and he testified to something else. And let me just add this. The trial court disbelieved every single thing that my client said. It's prerogative, it can do that. You're left with an evidentiary vacuum when you do that, however, as the Court of Appeals pointed out. But back to the facts of this case. So basically, child starts running off. Appropriately, my client tries to get her back.
Well, the whole reason for the disagreement between the child and the daddy is that the child had indicated where they lived, right? Or at least according to the child. That's what the trial court found.
That is what the trial court found.
And the daddy himself testified that at the time of the incident, this is finding fact 44, or at least what the trial court said he said, he was an absconder from probation, and if law enforcement had observed him at the scene of the incident, he would have been arrested and taken to jail.
Right, well, so the trial court found, the Court of Appeals found that 44 was not supported by the evidence, and the court, and even the majority and the dissent agreed there was no evidence to support that, 44 and 45.
But isn't it conceivable that the reason that the stepmother was unwilling to cooperate is because she was concerned that the government would have information about where her husband was living, and that the probation violation, parole violation, would catch up with him?
So, with all due respect, it's not reasonable, because there's no evidence in the record that would allow that.
Well, why did she
And
lie
that would be
then?
the type of-
Why did she lie?
She said she lied to protect him because he was on parole. She did not say that she lied to protect him because he was an absconder. And, both the Court of Appeals majority and the dissent found that there was no evidence to support, or held there was no evidence to support findings 44 and 45. And I think one of the problems in this case is, so the Court of Appeals majority, I believe, performed a very proper review of the record. So the standard of review on appeal is not the totality of evidence. That's never been the standard of review on appeal. And that is exactly what the dissent said it was.
This might be a good time for me to jump in, because I did have a question about that. So totality of the circumstances is a phrase that has a particular meaning, largely in the criminal context. But I'm not aware, is there any, sort of Black's Law style, like there's a technical meaning to totality of the evidence? Because to me, if there isn't one, totality of the evidence, just in ordinary English, just means all the evidence. It's not really standard at all. It's just saying you got to look at everything in the record and then apply whatever the proper standard is. So do you think that that's what the dissent was saying, or do you think the dissent was creating, some sort of technical meaning to that phrase that altered the standard that existed before?
Right, and to answer your question, I'm afraid so. I'm afraid that this dissent was doing that because the dissent cited this in re FS, I believe it is, I believe it's FS, that came out of Orange County, in which the Court of Appeals, per Judge Tyson, had stated that was the standard of review, the totality of the evidence, and in that case, the Court of Appeals, this was not brought up before this court, and there was not a divided panel. There was no petition for discretionary review filed that I'm aware of. But anyway, so in that case, the trial court had found that there was a likelihood of repetition of neglect with a second child because the mother had been hospitalized for substance abuse problems, I believe 9 times prior to the petition being filed. And the Court of Appeals held that that evidence wasn't probative enough based on the totality of the evidence standard, and that they chose instead to emphasize evidence of how many positive drug screens or alcohol screens the mother had had. And she'd had 8 negative screens, and they reweighed the evidence and found that that was more probative to neglect than the numerous hospitalizations, which the trial court had found were more probative to neglect. And it appears from that case that the Court of Appeals may have been looking at post-petition evidence, which is clearly against the statute. There's tons of cases on that. So I think if that's the case that's cited, I would say yes. And because that's what that case did, and that case is concerning for that reason, because the standard of review has always been, are the findings of fact supported by competent evidence? Okay? If so, do the findings of fact support the conclusions of law? And that's what the majority did. Now, what we have here that I think is very problematic is when you choose not to believe anything the dad says, all you're left with is basically the child ran into the road, dad was chasing her, and she almost got hit by this dump truck, okay? Now, that's really all you have. And, you hear the words being abandonment. The abandonment appears multiple times in
But that's not all you have, is it? I mean, the father left the scene and did not come back.
Well, what the evidence actually shows is that the child was placed in the car with this person, Mr. Sheeran, almost immediately after she ran across the road. What? Mr. Sheeran had trouble finding her. So she was hiding behind trees. She was hiding behind a telephone pole. This is actually a very rural area. I mean, if you're going to look at the map, too, that was provided in the appellee's brief, I would ask that you also look at the GPS on this from Google Maps, because this is a rural road. It's a 2-lane road. And just public record, or you can take judicial notice of this per the Department of Transportation, a lane is not going to be any more than 10 to 12 feet. So this is a road that's no more than 20 to 24 feet wide. So and this is also explained in the majority opinion. So child gets in Mr. Sheeran's car. Mr. Sheeran then testified, and it's very clear if you look at his testimony, that he hid the child because she said she was afraid of her father. So he let the child get into the car, his van with tinted windows, telling her there's tinted windows and your dad won't find you here. And
but are you what I'm sort of focused on or trying to focus on is, and if I'm wrong about this, I invite you to correct me, but that the father left the scene and did not return.
Right. Well, so the father testified at length that he did.
But he gave a version. The story that he gave is not reconcilable, is it, with Mr. Sheeran's testimony?
Well, it is actually, because
Mr.
Sheeran, the father testified that he came back later, and there were a bunch of people there, and he was confronted with just a bunch of insults and so forth, and that he then left because he just didn't want to get into something. But Mr. Sheeran didn't say. He said he didn't see father again, but it's not even clear how long Mr. Sheeran stayed at the scene because no one asked him that question.
I hope this isn't creative memory, but didn't the father also say that he saw his daughter with a lady?
He did.
And so that can't be reconciled with Mr. Sheeran's version of events, can it?
Well, no one asked Mr. Sheeran how long he stayed there, and there was a female social worker that appeared on that scene. And actually, the social worker, Valerie Neal, testified that she did, she came there about 4 p.m. Mr. Sheeran is saying this happened about 3:15, and that she did talk to the child. So, I mean, was that her? I don't know. But, I mean, in terms of who was there at that point, there were several police cars, according to Mr. Sheeran. I think he said there were several police cars, and then there was a social worker. Now, were there female officers in the police car? I don't know. I mean, I would ask that question. So I don't think it's not reconcilable. I think it is, but the trial court. I'm not even trying to go there because the trial court is the judge of credibility. But I guess my argument is that if you're not going to believe anything he says, then you're left in an evidentiary vacuum. So how do you get to this is endangerment? This is abandoning the child on the road. This wasn't a safe place for the child. If you cut everything out, and you look at the definition of neglect, and just the statutory definition of neglect, you have an improper environment that I think is relevant here, an improper environment. And so what was the improper environment? Child runs across the road, but we can't say it was dad ran her into the road. There's no evidence of that. She gets in the car with Mr. Sheeran, then she gets in the patrol car. So there's no what was the improper environment at that part? Or, you know, a pattern of behavior causing or potentially causing harm. There's no pattern of behavior, for sure. And I just want to address something, too, really quickly about the timeline here. So attached to my brief is a non-secure custody order, the first non-secure custody order, which is not in the record, and it should have been, but the addendum was allowed by this court. But it does show that the non-secure custody, the non-secure custody order was obtained that evening because it was approved or signed by the magistrate, which under the 7B can occur if it's after hours. And that's what happened. Maybe it was filed the next day. But the social worker also testified that right after she spoke to the stepmother, she went back to her office and started drafting the petition. And that was about 6 p.m., 5:45 or 6 p.m. So, you know, I mean, so you're talking about a period of time between 4 and maybe 5:45 that Dad did not so-called return. During that time, there's no evidence in the record he could have gotten custody of his child at that point in time. She was in Mr. Sharon's van. She was then in a patrol car. And in fact, again, Mr. Sharon heard the officer say that the windows of his car were even more tinted, so Dad would never see her. And then at that point, how long she was there, I don't know. But I don't think there was any evidence in the record that Dad could have gone and gotten the child. In fact, he said in his testimony, which was disregarded, that he wasn't comfortable trying to force his way into that situation, and that just wasn't something he was going to do. I think that's perfectly understandable. I mean, so also, and very important here about Dad not coming to pick her up. And so stepmother did testify she was on her way to pick the child up. She was on her way to pick the child up, and she was stopped by, she said, several patrol cars, including cars that were not marked. Now, the court didn't really make a finding about her credibility except to say that she lied about father's whereabouts, which she did. But the court did not make a finding about credibility in that regard, that she was off to try to find the child. Now, father testified that he asked mother to try to get the child after, you know, he decided to go back with the other 2 children. But of course, the court disbelieves that. However, the stepmother did testify that she was on the way to get the child when she was apprehended by all these police cars. You know, does it seem far-fetched there are all these police cars? Well, I mean, the social worker testified that there were police cars. In fact, the police cars escorted the social worker back to the house and wanted to go into the house, but the mother said no, and they didn't have a warrant, so that's not inappropriate. And so I may be running out of my time.
So what's your response to the argument that the department had no obligation to or should not have allowed the child to go with the stepmother because she wasn't a parent or a guardian?
I've never heard of such a thing. I mean, there's kinship placement. Why is it she can? And let me just switch on to dependency. There was no evidence whatsoever that anyone asked these parents about alternative caregivers. That is the evidentiary standard. There's so many cases that say that. That is required to the statute.
So, and the department, as I understand their argument, is that the father didn't try to contact them, and stepmother said that she didn't live there and wouldn't give them her backpack and was totally uncooperative.
Okay, well, and so stepmother did not testify that she didn't live there. She said they were in the process of living there. She was not totally uncooperative because the social worker testified that part of their standard protocol in investigating CPS complaints was to interview all the children. They did interview mother's oldest child, a middle school child, but they didn't interview the others because they weren't there. Mother said she had to pick them up, stepmother, and stepmother said, I'll bring them back and you can talk to them, or I can meet her, we can talk later, and or we can arrange a time to talk, but that was turned down. So they didn't even do their proper investigation. The key for dependency is that you have to make inquiries as to whether there's an alternative caregiver. The caregivers were stepmom and dad. Now, we know from the record, Dad testified, that his father was going to be in town that day or soon thereafter to help him aerate the lawn of their new house. So there's a grandfather. Dad testified as to his mother. Stepmother said that when Dad was working out of town because she was 9 months pregnant, she wasn't working, she had a high-risk pregnancy, that her sister was helping her with the kids, and she told, I believe she told the social worker that, and then you have a 9-year-old, who knows what relatives they have. I mean, if you're not going to ask about appropriate alternative caregivers, you just don't have dependency, because the statute does require that. In this case in particular, I don't think you could put an affirmative obligation on the parent to just come up with alternative, to say, oh, you're here to take my child. Let me think of appropriate alternative caregivers. These are people that they're not in the system, okay? It's not like a TPR case where, years have gone by, they've had a court-appointed attorney, and surely someone has talked to them about appropriate alternative caregivers, a judge, whatever. These are people who did not have attorneys, and, so how are they supposed to know to offer alternative caregivers? How would anyone that isn't familiar with 7B in that situation know that? And there is no evidence they asked. And that's why, it's my contention that this is not dependency or neglect. As to dependency, with respect to Mr. Freeman's argument, In Ray Hill was my case at Guilford County Department of Health and Human Services. Those were, in Ray Hill, the mother was in the hospital, the child was in the hospital for 2 days. During that time, Guilford County did contact relatives, as a matter of fact. If I remember correctly, the home study wasn't complete on the relatives, and I believe that one of the relatives had something like cancer, and there had to be a doctor's note, and there wasn't time to get a doctor's note, and she was an older person, like a great aunt or something like that, and they didn't feel like they could put the child in the care at the time. But it wasn't the case that Guilford County didn't try. And this court did not, this court actually reversed the Court of Appeals, and it was basically because my interpretation of it was that the Court of Appeals was considering post-petition evidence after the filing of the petition, because the father, it is true that the county couldn't find the father, but then they were looking at these other relatives, and that's exactly what the dependency statute requires departments to do. We don't want to take children out of homes so we can avoid it. It's very traumatizing. And so, the General Assembly puts the onus on social workers entirely properly to try to find a way to keep that from happening. That did not occur in this case. Also, just going back again to something that, and also, let me just talk about the findings. So I think Mr. Freeman was arguing in his brief that basically the finding that the parents couldn't provide an appropriate finding that they couldn't provide a proper plan of care substituted for the finding that there was no appropriate alternative caregivers. It is not. Those are two different standards altogether. Proper care comes from the neglect statute. Appropriate alternative caregiver comes from, the different section defining dependency. So they're not synonymous. If they were synonymous, then every dependency case would be neglect, and every neglect case would be dependency. That's just not the case. And there was no evidence anyway, so it's not a case where they can go back and pick up, a remand and with dependency, and just create and come up with new findings, because there's no evidence whatsoever that the department in this case tried to find appropriate alternative caregivers. And anyway, going back to neglect, I do think this case is like Stumbo. I am not arguing, and this was, I think, in some of the briefs that, and I think even with the Court of Appeals dissent, that a single incident of neglect is never neglect, or a single incident will never establish neglect. Of course it will. Let's take the child in that case. I think it was VM. Let's say the mother, the child had ingested alcohol by accident, and the Court of Appeals reversed or remanded, I think they remanded actually, saying that, there's no evidence here that the parent even knew about that. And if you look at the statute of neglect, there is a causality component. There's causality language. Did the parents, the environment that they maintained cause a substantial risk of harm? Now, if the mother in that case had known that there could be alcohol in the bottle, yes, that's neglect, because the child in that case ended up in the hospital. But that's a serious injury. But in this case, there was no injury. The child was not, in fact, left alone, which is one of the things that my client testified to, that, the Court of Appeals, the trial court decided that didn't find credible. But he said, look, in trying to figure out what to do with these, I have these two kids on the one hand, you can argue, I think, that as Stokes County did, that those kids were fine. Well, the little girl, according to my client, there's a 5-year-old and another 9-year-old. They were both his stepchildren. The 5-year-old child was crying, and he said was scared. And the little boy was doing things like saying he was going to get out of the car and try to look for her himself. And he's like, no, we're just going to stop this right now.
But we can't reweigh the evidence, right? I mean, it seems to me this case is very different from Stumbo, because in Stumbo, there was an anonymous report about the 2-year-old. The 2-year-old was not out on a busy street. There was no indication from the report that a parent knew that the child was outside or in any danger. Here, what the findings show, and I think, to the extent that we have findings that weren't challenged, we're bound by them, is that the father knew his daughter had wandered into a busy street, or had run onto a busy street, and he left.
As a matter of fact,
didn't the trial court find that he left the scene and didn't come back?
no, there's no. The trial court found he left, but the trial court did not find he saw the child run in front of the truck. And what the Court of Appeals, I totally agree with you. Of course, we can't reweigh the evidence. And that's exactly what the Court of Appeals said. The majority said we can't reweigh the evidence. We're just going to have to treat all this evidence that the trial court disregarded, and so the father's explanations, as non-credible, all of it. But, all you have is child gets to the road, almost runs in front of the car, and dad turns around. How do you infer from that dad saw?
Well, you have more than that, because in finding of fact 52, the trial court says that the father drove from Newsom Road to a convenience store to get drinks for the other children, and he did not return to the scene of the incident.
Again, I mean, when you take away all of his explanation, all you're left with is he didn't return to the scene. So you can't look at that and imply an improper motive. You can't imply any motive. I think this court, addressed those issues about presumptions and inferences from the evidence. I think it was KFC, that maybe KCT. Sorry, it's KCT. So KCT, is looking at a situation where there's just an absence of evidence, and saying that if you're going to imply or infer, something, it has to be reasonable and logical.
This isn't an absence of evidence. This is a finding that he didn't come back. I mean, that's evidence.
He didn't come back, but he sent a stepmother, and that was not held to be not credible. The child had been living with his stepmother for months, and so he sent the stepmother, who was also a co-giver. And I don't know why that would be neglect. I mean, if people are living in a home together and both of them are sharing child care duties, as the trial court found in Forsyth County, why would it be neglect if he sends a stepmother and not himself? He also testified that he needed to get gas, and he actually stopped at Circle K, and I think that's in the Guardian Lido's brief. So you got gas, and you got those other kids' drinks. But, in terms of, what happened in this case is that even the evidence presented by Stokes County was essentially that, Dad really didn't have an opportunity to do much of anything. And, and there were a lot of, police cars around stepmom, and she was on the way. And so how do you get from that to this is neglect because he just didn't come back? And when there's no evidence he had the opportunity to come back. When all evidence from the petitioner is he didn't have the opportunity to come back because the petitioner decided against their protocol to file the petition after approximately 2 hours of an investigation. And so I would respectfully, as I'm running out of time, I would respectfully request that this court affirm the majority, or in the alternative, I guess, send it back to the Court of Appeals, for clarity. But I would ask, I just don't think that's warranted. I think affirming the Court of Appeals majority is proper. Thank you.
Thank you, counsel. Rebuttal.
Just briefly, to Justice Newby's point about the absconding, I would point the court to page 132 of the transcript when the stepmother was asked about the brother that she said was there, who wasn't there. She says, my husband at the time was obviously in a situation where he had an absconding, questionable absconding situation. So I think that there is clear evidence from her testimony that that is what was motivating the lies that she told to the department following the incident. Counsel for the respondent father talked at length about the department's responsibility to make an inquiry about an alternative, appropriate child care situation. Make an inquiry of who? Their father was not available. The mother was not available. There was no parent to ask about an appropriate alternative child care situation.
And Counselor, if I could direct you to a question that was asked of your colleague on the other side. There was a question regarding the totality of the evidence and whether that might be the standard of care in Judge Flood's dissent. But right below that, when she writes about adjudicating neglect, she says, our standard of review instructs that, quote, the role of this court is reviewing the trial court's adjudication of neglect to determine whether the findings of fact are supported by clear, convincing evidence and whether the legal conclusions are supported by the findings of fact. Would you please address that from your point of view? Do you think, and I believe this was Justice Dietz' question originally, what do you make of the point of the totality of the evidence vis-a-vis this?
I agree with what I interpreted to be Justice Dietz's reading, in that totality of the evidence means all of the evidence. And I think I may have been in the reply brief for the department. It's part of the inquiry that the appellate court does in reviewing the evidence and the findings of fact to follow that standard of review, which is, are the findings based on competent evidence? Do the findings support the conclusion of law? So it's, it's necessary for the appellate court to look at all of the evidence in order to do that. And so I would say that totality of the evidence in this context means looking at all of the evidence, the totality of the circumstances, and evaluating whether or not there's competent evidence for the findings of fact, and in turn, whether those support the conclusion of law. Counsel for the respondent father spoke to part of the definition of neglect, but I would also point out that part of the definition of neglect is a neglected juvenile is one who is not provided proper care and supervision such that they are in a substantial risk of harm. That is the portion of the neglect statute that the trial court found was applicable here and made its findings of fact about, and those findings were supported. As to whether or not the father could have actually regained custody or control of this 9-year-old, I think the more determinative fact is that he didn't try.
And you say that because, in your view, sending the stepmother to inquire about what was going on was not him trying?
Well, I think that most of the evidence in that regard came in on disposition and not on adjudication. But there was evidence at adjudication that the father was trying to liaise or coordinate with the stepmother in some way. But the adjudicatory, I would not say the adjudication evidence would support a finding of fact that he was sending her in his stead. I do think that she had some testimony to that effect that came in later on disposition, but that's a lower standard of proof. It can't support an adjudicatory finding of fact. And with that definition of neglect that the trial court did make its findings of fact toward and did in fact find, I would say the trial court was correct in doing that, or at least had the evidence there to support it, and that it should be affirmed. And I do believe that Mr. Freeman has a short rebuttal as well.
Very short. To Justice Allen's point, This case would be totally different if the father had made any efforts whatsoever to come back, to call, to show any amount of concern for his daughter that he had left on the side of a road by herself, crying after almost being hit by a dump truck at any point in the 24 hours after that before the petition was filed. Because even though the department had taken temporary custody before filing the petition, they had the ability under 7B 501 to release the child to the parent to not file the petition. No efforts were made by the father. We would ask you to reinstate the finding of neglect and dependency in this matter. Thank you very much.
Thank you. Mr. Clerk.